display of empathy should not be considered an admission of guilt. That guilt is established in the bedrock of our criminal procedure that is from the prosecution. And in this case, that was riddled with numerous errors. That standard was not met. We believe the most compelling arguments are the testimony of Ms. Kelsey Harris when looking at the confrontation clause, prosecutorial comments in the opening and closing statements, and Brady violations that cumulatively occurred throughout the trial. To start with the confrontation clause, particularly with Ms. Harris, who was present in court and also present on the night in question with Mr. Peterson, Ms. Pete, and Mr. Smith on July 12th, 2020. Ms. Harris gave testimony on December 14th and 15th. These dates are important to note, but she only gave that testimony after asserting her Fifth Amendment rights. With the confrontation clause, what we must do is a very fact-specific analysis, and we must weigh Ms. Harris's right to not self-incriminate with Mr. Peterson's right under the Sixth Amendment to confront those witnesses. Because of this, we have to analyze this and take it step by step. So the first step is seeing if we have a testimonial statement. And this is according to Crawford v. Washington, 2004, 541 U.S. 36. These statements were further defined whether to be testimonial or non-testimonial by the High Court in Davis v. Indiana, which is found at 547 U.S. 813 in 2006. Statements are testimonial when the emergency no longer arises, when the statement is being given in response to a future prosecutorial event. So we know that Ms. Harris, when she gave her interview with the district attorney's office, was giving a testimonial statement. Therefore, the first prong is met. But the second prong is not so easy to establish. We need to determine if Ms. Harris was available or unavailable, which is a little tricky in this case, which is why we need to walk through each step. So Ms. Harris walked into court and said, I exercise my Fifth Amendment right. That made her unavailable. But when they granted her use immunity, she was thereby available again. Yet she still got on the stand and testified in a manner that was not consistent. She said, I don't remember. Or she said, I was dishonest in my interview with the district attorney's office. Therefore, because of the way she was testifying, they decided at first to take this interview, which at the time we did not have a transcript for. And they were playing portions of the recorded statement to refresh her memory that the jury heard. So at first, that was going on in her direct. Then in her cross-examination, as she continued to testify in this varying manner that wasn't the way everyone expected her to testify, they entered the entire into evidence. But that recording was not entered into evidence while Ms. Harris was giving her testimony. It was entered into evidence on December 16th. And at that point, this is when the defense received that transcript, which we argue not receiving that transcript was a violation of Brady, and it also was a violation of Penal Code 1054.7, Your Honors. So we have this now statement in evidence, which is a transcript of a testimonial statement given to the prosecutors. In order to get this into evidence, they have first argued that they were going to use it to impeach Ms. Harris. This is because in their opening statements, the prosecutor said that Ms. Harris was going to testify that Mr. Peterson had violently pulled her by her hair from the car. This is a fact that was not proven at trial. Ms. Harris did not testify to this. Therefore, we feel that also is one of the inappropriate opening arguments. But additionally to that, we strongly
Is she making this up as she
objected
go
to the
along?
late discovery
Like this
of this
video, like
transcript.
this
And it
video,
wasn't
like
just
this
the
video.
late transcript. There were numerous other instances that the trial attorney did object to. But nonetheless, ultimately, the court did admit this statement under both Evidence Code 1235 and Substantive Evidence Code 770. So now it's in, and we have a very unique situation here where we have a testimonial statement. We have a witness that doesn't want to give us answers and is saying I was mistruthful in my interview only in September of 2022, and this trial was in December of 2022. So it's clear that she did not want to cooperate. She said as much on the stand, I don't want to be here today. As a result, these matters, we feel that we need to look at the reliability and the prejudice to Mr. Peterson. And as Ms. Harris stated, I didn't tell the truth. So we can't rely on these statements from her own words. And this did greatly prejudice Mr. Peterson because in that interview,
When did she
Ms.
say she
Harris
ain't telling
said,
the truth?
my friend and I were attacked and it was this man's fault. And then in trial, she did not verify those statements, but the jury
She said she
still
did not
heard those
recall.
statements nonetheless. And we know that the jury relied on these statements because during deliberations, they did ask for a copy of that transcript to further analyze it. Therefore, we feel that the totality of the circumstance
Because she
really does
refused
show
to
that
cooperate in court,
Mr.
they
Peterson didn't
played
have a
her
chance to confront that witness
testimony
in the Sixth Amendment context.
that was recorded
Additional errors occurred
by the police.
Throughout opening and closing statements. Start with the opening statements. We heard the prosecutor promise that he was going to put Mr. Justin Edison on the stand and that Mr. Edison would say that the following day when Mr.
Tory
Peterson met with
attorney.
him to give Miss Pete and Miss Harris's belongings to him, that Mr. Peterson confessed that he did this crime. So the jury in opening statements at their first introduction to Mr. Peterson heard he's guilty and he said so, and I'm going to put a witness on the stand to prove it. But Mr. Edison never testified in the trial. Mr. Edison was not being cooperative with the prosecutors. In fact, in November 28th, 2022, the court had to put a body attachment onto Mr. Edison. And on December 5th of 2022, Mr. Medesian, our trial attorney, actually filed a motion in limine specifically for this. And he stated that he was very concerned that Mr. Edison not coming to court would severely prejudice Mr. Peterson. And he urged the court to not allow such statements in opening. This motion was not granted. And so the court heard that Mr. Edison was going to testify. When Mr. Edison didn't show up due to media coverage and comments made in the trial, it was implied that Mr. Peterson was responsible for Mr. Edison not being in court with no proof of such contentions, which further prejudiced the jury. The body attachment continued at that point, and he still did not cooperate with the prosecution. We know in California, due to Hawk v. Superior Court, which is found at 42 Cal Ave 3D 108 in 1974.
Additional witnesses.
This is the controlling case that supports the contention that opening statements are confined to a reasonable good belief of what the prosecutor feels he will be able to show in the trial.
He got 10 years.
Reasonable good faith arguably, very respectfully, is not having a body attachment on a witness. The witness may or may not be trying to avoid the process. We don't know. He's just not there. And so that's all we can rely on. And ultimately, what happened is exactly what Mr. Medesian was afraid of in his motion in limine. And what Hawk warns about is that we must have this reasonable good belief in these opening statements to promise something, especially when it comes to a confession, because the jury is going to believe the prosecutor. They're going to rely on those words and have the prosecutor guide them and direct them to show why Mr. Peterson was guilty. So because of the great weight that the jury naturally gives the prosecution, we feel that these statements were inapposite to a good faith belief. Generally, a court would give a limiting instruction and attempt to cure such a situation. But in Mr. Peterson's court, no such instruction was given. There was no curative instruction for these opening arguments.
So let me ask a question here. So are you arguing that any time a witness is subject to a body attachment, that should be, that any reference to that witness should be off limits in opening statement?
I think that the prosecutor should be extra careful in such a situation because they're going into this knowing that that witness is not cooperative. So I think that if they say that they hope to produce such a witness, that perhaps would be enough. But here, there was just no hesitation. And I think it's especially true in the case of the evidence that we're dealing with Mr. Peterson, that it was a confession.
And so what was the evidence or indication that the people did not have a reasonable good faith belief that they would be able to produce Mr. Edison at trial?
We actually have no proof of the district attorneys ever speaking to Mr. Edison. The defense was never provided of a copy of any interview that they conducted on this witness. We have no physical evidence. All we have is an email from the district attorney in this case that said, I didn't disclose this and I meant to disclose it, but we are going to call this witness who will say that Mr. Peterson confessed to him. So I honestly, despite my best investigations, we cannot find where this statement came from. We cannot ascertain the veracity of these statements. That's why I think it's inappropriate. I don't think it's always inappropriate, but in this case, with these particular facts, I do feel that it's inappropriate. And there was also problems in closing arguments, which contained inaccuracies, and it presented the evidence in a way that misconstrued the actual results. Here, I'm specifically talking about the DNA evidence. So we heard the prosecutor close the case by telling the jury, don't be fooled when we hear that Mr. Peterson is excluded. But that's not exactly what the evidence said, which they had in their possession. I feel that statement really misled the jury. It may have confused them. It played on their emotions. And we know that that's not appropriate in closing statements. And in order to really understand the weight of that statement in closing, we need to understand what the evidence was that the district attorney had available to them. So as shown in our brief, in our reply brief, as for the magazine, there were 4 DNA profiles discovered on the magazine, none of which that were Mr. Peterson. Therefore, he was excluded from the magazine. As far as the firearm goes, they also found 4 different samples, one of which was a 90% male contributor. But Mr. Peterson was excluded from being that 90% contributor. Therefore, telling the jury, don't be fooled when you hear he's excluded is just not quite as the evidence showed. And to illustrate this,
because his DNA wasn't on the
I want to
gun doesn't
clarify
mean
some
he didn't
key
fire it.
terms in science.
What about the gunshot residue
So
that was found on his hand?
inconclusive, we heard in trial testimony,
What about the
means
gun
it's
being
not
found under his
positive,
seat?
it's not negative,
What about the
it's
gun
just a
still being
neutral
hot when the
result.
police
But
got
it's
there?
not quite as simple as that.
What about Tory
Actually,
Lanez
according to the
saying
scale
that
of
Megan will never
likelihood
forgive me?
ratio, which was in the discovery and presented at
What
trial,
about Kelsey texting,
likelihood ratios
help,
are the
Tory shot Meg?
percentages. And we did not hear any percentages in Mr. Peterson's case, even though this evidence was available to the prosecution. This evidence was only given to defense upon our expert witness's request. So we did receive this evidence late. So this evidence was not presented in trial. It was presented in the motion for a new trial. But what we can see is that likelihood ratios that are 0, 0.01 and below are considered to be excluded. Likelihood ratios from 10,000 to 999,099 are very strong, very, very strong support to the prosecution that this person did leave DNA on this item. And then above 1 million is very, very strong. We found in the DNA evidence that they labeled Mr. Peterson's LR to be inconclusive and uninformative. And uninformative, according to this scale, is an LR of 1.
Not excluded.
Therefore, Mr. Peterson had an LR of 1 in a million that his DNA was on this firearm. And with that fact, it is actually marginally more likely that another member of the African-American population touched this gun over Mr. Peterson, which the jury did not hear. The jury heard the district attorney say, don't be fooled. But there's also no proof that Mr. Peterson did anything to fool anyone about this evidence. He presented his defense. It was their testing. We went off of what their testing said. So I just think that that is a very strong contention. People v. Berryman in 1999, 21 Cal 4th to 50 is a significant California Supreme case that addresses the standard for overturning a conviction due to prosecutorial misconduct.
Tory and Kelsey,
it's a principle.
To create,
basically, the key outcome of that case was that we must show that this misconduct materially affected the outcome of the trial.
Yeah, that's what that was.
And it did. Because if our jury had heard that Mr. Peterson maybe 1 in a million touched the gun, I believe that would have been enough to tip that scale and show reasonable doubt for them to find him not guilty. The jury just didn't hear that. They heard that Mr. Peterson hoped that they would be hoodwinked in the alleged closing arguments. So due to these statements and the misconstruing of the evidence, we feel that that was a very significant issue in the case. And finally, we feel that the Instagram post, as we discussed in our opening brief, this was a Brady violation. This post was given not only late, but it also was not redacted. It was riddled with hearsay. This post is significant as it also implies a confession, because what we have is actually various people posting, and this was in September of 2020, and they were posting that people were saying that, oh, well, if Mr. Peterson didn't do it, then Ms. Harris must have done it. And Mr. Peterson's social media manager commented on this post, no, they're not. And so that was used as an admission. But many celebrities don't run their own social media accounts. This is significant because, number one, had that discovery been given timely, we could have provided the statement that was provided in the motion for a new trial by Mr. Farias, stating that he is the one who runs Mr. Peterson's social media account. He made that post, and he didn't ask Mr. Peterson before he made that post. So that right there, we could have, if it was not
Talking
late,
about the post where he stated
presented a
that
defense, but
did not
because
shoot
we
Megan.
didn't
Yeah,
have that,
Tory
we were caught
posted
off
that.
guard. We were always in a position of reactive instead of
Chelsea didn't
actually
shoot
being
Megan,
able
and Megan
to
ain't shoot
produce a
herself.
good defense on this case. The Brady rule provides.
Let me just ask one question at one thing you said.
Yes.
Were there requests for redaction of that exhibit? Or
I believe there were, yes. Mr. Medesian did do a very good job objecting throughout the trial. We also must remember that Medesian only took over this case 2 weeks to a month prior the start of the trial, because the first trial attorney did withdraw and was permitted by court. Yet I understand the court allowed that, but as an attorney, that's a very big feat to step in the shoes of another attorney so close to the trial. So I feel that all of these arguments we're discussing today, we do need to take that into consideration overall with them and think, in the alternative, this could be an effective assistance of counsel. But the Brady rule provides that this exculpatory evidence must be provided to defense whether or not a request was made. The suppression of this evidence, it doesn't matter if it's willful or accidental, so long as it was suppressed, then that is the problem right there. And I do have a 3-part test, which is found in the United States Supreme Court in Strickler v. Green, which is 527 U.S. 63, 1999. They reiterated the evidence must be favorable to the defendant. Here, yes, the evidence was favorable. Had we gotten that Instagram post earlier, we could have brought that declaration in trial saying Mr. Peterson doesn't run his own social media. Had we gotten the DNA evidence and not had to request that from the prosecution, we could have prepared for a better DNA argument, having the full picture. Had we had the testimony, the transcripts from Ms. Harris's interview, we could have countered that. We could have questioned her on cross about her interview. We also likely did not get fingerprint evidence on time. We did not get, and the fingerprint evidence actually showed that Mr. Peterson's fingerprints, were not found on that weapon. Currently, we are attempting at the Superior Court to have them run the serial number to identify the owner of the weapon, which was not done. And we are also attempting to retrieve either a recording or a transcript of one of the key witnesses.
All that's going to do is prove that it's Tory's gun.
I'm sorry, one of the key witnesses in the case, Mr. Sean Hawley, who gave testimony. We're attempting to get a copy of his 911 call.
Wait, which you said Sean Hawley?
Sean Kelly.
Oh, okay. I'm sorry.
Yes.
I thought you were referring to counsel who's female. Okay.
Yeah, no, very close. Yes, Sean Hawley was the attorney. Sean Kelly was the witness.
Okay, got it.
Different spellings also. So obviously we can see that this is favorable. The second question under that 3-part analysis with Strickler was it suppressed willfully or accidentally? Yes. This evidence was suppressed. All of these different pieces to where Mr. Medesian said, I feel like every day I wake up and I have an email from either the night before or the morning of saying, oh, we missed giving you this. And very respectfully, I say that. And the final component of this 3-prong test is, would it have changed the outcome of the trial? Yes. Absolutely. If our jury could have heard the full picture, the full accurate picture of just the evidence being laid out as it was, without these don't be fooled told and, late discovery, I feel that it would have really tipped those scales to reasonable doubt to find that Mr. Peterson was innocent. And that's why today we humbly, humbly pray for exoneration of Mr. Daystar Peterson.
No.
Thank you very much.
Thank you.
Absolutely not. Hell no. To the no, no, no. That argument was terrible. How much did he pay for that? My.
Morning, Your Honors. May it please the Court, Deputy Attorney General Michael Keller for the respondent. I want to begin by discussing the compelling nature of the evidence in this case. Within minutes of the shooting, the police found the gun that was used under appellant's seat. There were only 4 people in the car. Pete and Harris both identified appellant as a shooter. That first ID occurred within minutes of the shooting when Harris sent a text to a member of Pete's security team saying, "Help, Tory shot Meg, 911." Right. Harris again ID'd appellant as a shooter in the recorded statement, and we can get to that in a moment.
Make it make sense.
And Pete identified appellant as a shooter both before trial and at trial.
She was all over the place.
Neither of them ever suggested that anyone other than appellant fired the shots. Now, there's 3 times in which appellant tacitly admitted being the shooter. The first is hours after the shooting, appellant made a recorded call to Harris stating that he didn't even remember what they were arguing about, and he wanted to know the hospital where Pete was being treated. He blamed alcohol for the quote unquote shit that he did. Now, the second one was later that day, appellant sent a text to Pete, to the victim, and that text was preserved. In it, appellant said Pete would probably never talk to him again, that he was sorry, and he blamed again the alcohol for the quote unquote shit that never should have happened. And then the third and final is the verified Instagram post that I'll also get to. Now, appellant's assertion is that he really wasn't accepting blame for having shot Pete, but for causing a rift in the relationship between Pete and Harris. And that's just nonsensical. First of all, Harris told appellant she was at the hospital waiting for Pete. So if there had been a momentary rift that night, it was over because she's now at the hospital waiting for her friend that she's known for 7 years to be released and checking on her. Second, appellant didn't apologize to Harris, but yet he anticipated that Pete would never talk to him again. He was clearly accepting responsibility for something very big, something that applied to Pete, but not to Harris. And as appellant said he couldn't remember what they'd argued about, he wasn't accepting blame for anything he said. Finally, appellant said that he expected to receive backlash once word got out. Now, backlash for causing a rift makes no sense, but backlash for shooting someone does. The evidence in this case was compelling. Turning to a few of the issues that have been highlighted here today, I'll start first with the Instagram post. This was appellant's verified account. And a few times today I heard opposing counsel mention Brady, but Brady was never mentioned in appellant's opening brief or the reply brief. It can't be raised for the first time at oral argument. And frankly, it has no application here because the things that were turned over were inculpatory, not exculpatory. So when it comes to the Instagram posts, they were turned over upon realizing them, and there was no, many of the case, as you'll see in the respondent's brief, many of the claims that appellant raises are forfeited by a lack of objection at trial. And one of the things Your Honor asked is, did counsel ever ask for redaction? I don't see that anywhere in the record when it came to the Instagram posts. In fact, counsel didn't even object on the discovery basis. The objection was solely based on foundation. So discovery doesn't work for appellant on appeal. And as to foundation, the question really is whether or not there is an inference that can be drawn that a statement was made by a party. If so, it falls under the party opponent exception to the hearsay rule. And in this case, it's a verified account. And the fact that
shortly.
there may have been somebody else who had access to it to respond and may or may not have had permission, that would all go to weight, not to admissibility. Turning to the issue raised about the Harris recording.
Let me ask a question about the Instagram post before you move away from that. And I guess the question is, if there were some sort of error in admitting that post, what would your argument be about as to whether that was prejudicial or not?
Yeah, it certainly wouldn't be prejudicial, Your Honor, because first of all, at trial, it came out about these other aspects. In other words, do we know for sure whether or not this was appellant personally authored or approved of it? There's some question about it. But what we do know is he did send the text. What we do know is he did make the recorded phone call. Like, that's his voice. So, and by the way, I would say that on the Instagram post, the post, all it said was, Harris didn't do the shooting. He didn't say, I did the shooting in that. So it's no more incriminating than the other admissions that came from his phone in a text or in person in a voice recorded call. So turning to the tape recorded statements that were made by Harris to impeach her as prior inconsistent statements. When she was on the witness stand and made a number of inconsistent statements, the prosecution impeached her with those prior statements. Much of the recording, pieces of the recording came out during that period of time. While she was still on direct exam, the prosecutor announced a desire to play the entire recording at a subsequent time. And that was that's 5RT 3664 through 3665. Now, this puts the defense on notice that the entire recording is going to be played. The defense has an opportunity to object to it, to portions of it, and counsel doesn't do so. Counsel instead has an opportunity then to cross-examine on anything and everything that's in the recording because counsel knows that the entire recording is going to come in. So a confrontation clause claim just doesn't lie. And then I would add that on top of it, Harris wasn't excused as a witness. At the end of Harris's testimony, I see nothing that would preclude Harris from recall. So a confrontation clause is for when the defense doesn't have an opportunity to cross-examine a person on it. Harris testified, although Harris initially took the fifth, Harris was given immunity, subsequently testified. So the confrontation clause just does not work on appeal. And lastly, I'll turn to the allegations of prosecutorial misconduct. On that, again, these are forfeited claims. Objections weren't raised. Your Honor asked a question about how do we know on good faith, bad faith versus, there was a body attachment. You have a prosecutor that is, because the trial court did inquire into it, and the prosecutor said that the witness was under subpoena, and the prosecutor said they had a good faith. That's a judgment for the trial court. Now, I would note that if the defense counsel wanted more information about it, that was the time to raise it and to try to develop more details right then and there before the ruling as to whether or not this witness was going to be available and whether the prosecutor actually had a good faith. And the defense's failure to do so precludes the claim from being raised on appeal. And one of the things I'll note that is in the reply brief as to these allegations of misconduct that weren't raised below, the reply says, well, an objection would have been futile because it would have run the risk of highlighting the issue for the jury. That's not what decisions involving futility involved. The futility exception applies only if the record shows that the objection would have been overruled or that nothing could have been done in a curative fashion, not just that it might highlight an issue for the jury and the attorney had a tactical reason for not doing so. Unless the court has any questions, I'm prepared to submit on the brief and ask this court to affirm the judgment.
We have none. Thank you very much.
Thank you.
Ate her ass alive.
Any rebuttal?
Yes, briefly.
Now she got a rebuttal. You better get up
But
there and say
regarding
something,
the
girl.
text
All that money
to
Tory
Mr.
giving you.
Edison, there was actually a motion in limine filed regarding that text. It was filed on December 12th, 2022 by Mr. Medesian. He stated that without Mr. Edison present in trial and without the foundation laid, that this text message shouldn't be admitted. That objection also was not granted by the court, but was on the record nonetheless. I've heard the people say that there was not compelling evidence, or there was compelling evidence, excuse me, to find Mr. Peterson guilty, but I argue that there was not enough evidence because we talked about the physical evidence in this case and the lack of physical evidence in this case. We discussed the variance testimony where even today, it's still not quite clear what happened on that night. And I also want to talk about the Instagram post. The fact that Mr. Peterson didn't say, well, you know, it wasn't Miss Harris and it was me, that really doesn't matter. There were only 4 people present the night in question. One was Mrs. Pete, one was Mr. Smith, who was the driver, leaving only Mr. Peterson or Miss Harris in possession of that weapon doing the acts that we're here for today. Therefore, it doesn't matter if he didn't confess.
Well, he already said that
it was
he
an
knew it, so it must
implied
have been him.
confession because there was no question as to whether Mr. Smith or Miss Pete ever did these actions. I would like to remind everyone that Brady is willful or accidental. Brady says that regardless, the defense has a right to the evidence that's being produced against them in court. The incidents were very significant. The pieces that we were not given would have changed the outcome in this trial. For example, with the Harris recording, there also was an objection there for the Harris recording. That goes back to our motion in limine on December 5th. And in that, when there also was a sidebar as this was going on and these statements were being played to first refresh Ms. Harris's memory, you know, Mr. Medesian did object and there was a sidebar and the judge actually commented that it's just easier this way. And Mr. Medesian said, but procedure, and the judge said, no, it's fine. We're going to do it this way today. So those objections were raised in the courts. Those weren't waived. And honestly, as far as recalling Ms. Harris, there was no body attachment. She stated, I don't want to be here. I don't want to do this. She stated, I have not been truthful. And that's, I can't speak for Mr. Medesian. So there is no record of why or why not she was not recalled. But I feel that the people did just make a good point that it was futile. I feel that at this point, Mr. Medesian very respectfully did feel defeated. He did feel overwhelmed. He stated in his objection, I wake up every day and have an email from late last night or this morning with another piece of evidence that the people forgot to give us. And I do feel that he lost some of his steam there, so to speak. And because of that, you know, that's why I reminded the court that he had a very short time to prepare, and any objections that were missed should be construed as ineffective assistance of counsel.
have been
And
compromised.
that I submit.
And I've been saying that from the very
All
beginning.
right. Thank you both very much. The matter
Got it.
stands submitted.
The neighbor ain't said that, friend. The neighbor ain't said the woman that shot. The neighbor came to court and said he seen it was Tory. That's what the neighbor said. I was sitting there in court. He said it looked like there was a struggle.
Yes,
Like
we're in
us
recess
tried to stop
until
him.
1 p.m. Thank you.
Which makes more sense. That's why there was good.
Thanks.
Don't give me the soccer wig. It's good. Like this video, like this video, like this video. Did they just go on a recess? Did they just take a recess? My. Oh, that's the end of the afternoon session. My. Like this video, like this video, like this the video where it's the Fish King Pain Show. Act like you know where you're at. We got a lot of things to get into. We and for the girls in the back that's just pulling up. Make sure that you guys are liking this video. Like this video where. So what's going on? Okay. Tory Lanez, whose real name is Daystar Peterson, is appearing before the California Court of Appeals in Los Angeles today. Okay. That is the oral argument that we just watched. Okay. And this appeal is to overturn his 2022 felony convictions related to the 2020 shooting of Megan Thee Stallion. Lanez was convicted on 3 felony counts: assault with a semi-automatic firearm, carrying a loaded, unregistered firearm in a vehicle, and negligent discharge of a firearm. Guilty, guilty, guilty. I was there in the courthouse when the jury came back with the verdict. He was sentenced to 10 years in prison in August 2023. The hearing marks a critical moment in his ongoing effort to challenge the conviction, with his legal team arguing that procedural errors, prosecutorial misconduct, and issues like inappropriate narrative testimony from Megan Thee Stallion and improper emotional appeals to the jury undermine the fairness of the trial. We just heard the argument from Tory's attorney. What are your thoughts? Did she do a good job? Somebody said they just spending Tory's money. They just sucking Tory dry. My. Like this video, like this video. Hey, Bobby. Hey, friend. Long time no see. How are you and the baby? Yes, it did. You are obviously biased towards making LOL clear as day that Tory is innocent. Tory is not innocent. What is clear about it? You want to argue? Here, click the link. Okay, on period. That's what this is all about, Win. Okay, on period. Click the link. Let's argue. You bring your evidence. I'll bring mine. Okay, on period. Because who gonna check me, Win? I was there. You wasn't there. Okay, I was there. Yes, it did. Like this video. Like this video, Win. Yeah, this is crazy. Her best friend did it because why was there no gunpowder on Tory hands, but it was on the nope. There was gunshot residue on both Tory and Kelsey's hands, because Kelsey was struggling with Tory for he wouldn't unalive Megan. Yes, it did. When he started shooting, she got to grabbing. Yes, it did. That's what Sean Kelly said. Yes, he did. That's what he said. They were standing outside. Okay, on period. Tory got the busing. Yeah, and then Kelsey got to, like, what are you doing? Type of thing, Yeah, you have to be there in court, friend. I'm trying to told you when. And then there's this other narrative where he was shooting over the window like this. So I don't know. He was just having fun with it, if you ask me. Yes, it did. Yes, it did. But Tory shot. Tory was the one who shot. Tory's the gunman. Tory is the gunman. Yes, it did. Like this video. Even Megan said it. Megan said Tory shot me. Tory shot me. If Kelsey shot her, wouldn't she want Kelsey to be locked up? Kelsey just out there free, able to come and shoot her again. Like, why would she not tell that Kelsey shot her if Kelsey is the one that shot her. Like, come on now, make it make sense. Tory shot Megan. Everybody know that. Okay? Everybody know that. I'm not biased. I'm just logical. Okay. I mean, it only makes sense. Okay, so recently on August 12, 2025, the California Court of Appeals rejected 2 habeas corpus petitions Lanez filed, which claims that key evidence such as the gun used in the shooting and bullet fragments was mishandled or missing, and included testimony from a bodyguard, Bradley James, alleging that Kelsey Harris, Megan's former friend, admitted to the shooting. Look, Bradley James, okay, on period. If you wanted to be included in this trial, your bitch ass would have showed up to court. We were looking for you. Everybody was looking for you. He gonna show up the last day. The jury has already deliberated. Talk about he got something to say. No, it's too late. Go back to where was you at? Where'd you run and hide? Yeah, just going back to where you came from whence you came. He is clearly been compromised because he's trying too hard to have his testimony included after the fact. How much is Tory paying you? Because you had an opportunity to be there in court and testify, and you disappeared. We were looking for, everybody was looking for the bodyguard, the driver, the 4th person in the car who could have possibly shot Megan. He was absent, nowhere to be found. Yes, it did. Fisher King got all of the receipts. Like this video, like this video, like this video. Now, granted, the bullet fragments being missing, you know what I'm saying? You know, Megan said initially it was glass that she had stepped on when. Does it negate, okay, the fact that Tory had this gun and he was out there discharging this weapon negligently? Yes, it did. Those bullets went into homes. Sean Kelly said that there was a bullet hole 2 inches away from his child's head. He heard the commotion outside. He went out on his patio to see Tory and Kelsey tussling. 5 shots rang out. He said at one point it looked like, okay, if anything, Kelsey and Tory did it together. If anything, they did it motherfucker together, because he said that it looked like at one point they was carrying Megan's body over into the lake. They were trying to throw Megan in the lake, but Megan kept kicking. She kept kicking with them long ass legs, and they couldn't get her ass win. Okay, on period. Yes, he did. That's what he said when. That's what he said when they was fighting to get her in the car. Like this video, like, I was there. Okay, I was in the courthouse when he said that they were trying to dump the body, but Megan kept fighting. She started waking up the neighbors with them hooves. And they had to get up out of there. They must have heard the sirens or something. It was time to go. They was like, fuck this shit. Let's just get in the car. I like the video, like this video when I was there. Okay, on period. So the bodyguard is alleging that Kelsey admitted to him that she shot Megan. Like, then why would Kelsey text that Tory shot Meg minutes after Megan was shot? All they're really trying to do is create reasonable doubt What he's saying is if the bodyguard would have been there, if the bodyguard would have been allowed to testify, this would have created enough reasonable doubt to where possibly Tory Lanez would have not been found guilty. You know, he's trying to create all of this confusion when it's clear what had happened when. It's clear. I can see it. I can see it. My. Tory is not getting out. I don't think the Tory is getting out when okay on period. I think the appeal is going to be rejected. We just heard the oral arguments. What are your thoughts? Let me know in the chat. Talk to me. I talk back. Yes, it did. The court dismissed these previous appeals, stating the gun was still at the Los Angeles Police Department and that additional DNA testing wouldn't establish Lanez's innocence, as prior tests showed inconclusive. Okay, not excluded. It said inconclusive. Do y'all know what inconclusive means? It means we can't tell whether it is or it isn't. If it is or if it isn't. That does not mean he's excluded. I mean, bitch, we don't know. We can't tell. It's a toss up. Could have been. And we all know it is. It is. He shot Megan. She ID'd the assailant. She said, Tory shot me. Kelsey said, Tory shot Meg. Sean Kelly said, Tory shot Meg. I was there at the courthouse. He came, he sat down, he testified. He said, Tory shot Megan. That's what he said in court. They kept trying to say, oh, it was Kelsey. He said, no. They kept trying to, defense attorneys kept trying to spin it. They kept, word salad, all this stuff. They kept trying to trick him, like walk him into saying that it was Kelsey or somebody else who shot the gun, and he did not. He was adamant. I can go and pull the transcript. He kept saying over and over, no, it was Tory who fired the gun. He said that over and over. No, it was Tory. No, I seen Tory with the gun. No, the fire, the sparks came from Tory. Kept saying that. Yes, he did. I was there. Like this video, like this video, like this video. Not to mention the G was pink. Why would Tory have a pink G? Girl, you don't want me to answer that. Yes, it did. She kept repeating the same thing. She did. The attorney that he hired, she's a new attorney. She's supposed to be good or something. Wait, girl, look like she wasting she's spending that money. He letting them spend his money. He wants to get out, but it's not happening. I know that's right. Shout out to everybody here. Shout out to everybody watching. You guys remember to support the show. The number of the day is 10. We got Cash App, Super Chat, Venmo, Zelle, Crypto, however you want to do it. When my. Oh, you think they're gonna come back after break and tell us that the appeal has been rejected? Let me know your thoughts in the chat. When he still would have to do time because he has a previous gun charge. You are not supposed to be around guns. Anywho, absolutely. Yeah, and he's trying to win by default. He's not even trying to win on the under the guise, oh, he didn't shoot Megan. He's trying to win under, oh, it was malpractice. There was misconduct. Like they didn't handle me correctly. Like, girl, go sit your pussy ass down. Yes, it did. Let me tell you something. You don't know female talk. My. Megan didn't want her friend mad at her for doing something with her man. You're not a woman, so why you don't know how a woman think? My. Well, excuse me. And excuse me, girl. I don't know. This was a woman thing. They say that the black woman is the most disrespected. Okay, yes, it is. and unprotected. So you might be on to something there. Okay, on period. At the end of the day, okay, Megan and Kelsey was gonna stick together no matter which stick they were sharing. Let me know in the chat. I don't get it. What am I missing? It's woman talk. Is there a woman here who can clear it up for me? Because my presence, I clearly didn't mean nothing. Support the show. Their turn are feeding off of Daystar. Period. Period. My. Like this video. Like this video. Like this video. Yes, it is. Back to the receipts win. Okay, on period. The court also found the bodyguard's testimony untimely and insufficient. Absolutely, he had his chance. Okay, on period. I don't know what they think is going on. They're talking about had certain individuals been given the opportunity to testify that this would have, mind you, these are the prosecution's witnesses. Tory had an opportunity to bring his own witnesses. Tory had an opportunity to even testify, and they did not. So, I mean, this was a choice that you made, a decision that you made, and unfortunately, you got to live with it. You could have fought harder. You should have fought harder when it was time. Yes, it did. Yes, it did. Like this video, like this video, like this. It's been that long. I've been at it that long. I can't. It's not been that long. Like this video, like this video, like this video. Win, gather in, close win. So despite these setbacks, today's hearing focused on Lane's main appeal where his team argued the challenge, where the team argued and challenged the whole conviction in its entirety, potentially raising issues about evidence handling, witness credibility, and trial fairness. The outcome of this appeal isn't expected immediately, as rulings typically follow weeks or months after oral arguments. Oh, so we're not going to hear back today as to, whether or not it was rejected, but chances are it's going to get rejected like the others, especially when it comes to him talking about witness credibility and trial fairness. Now, it was a very fair trial win. Okay, the judge was not playing. Okay, and witness credibility, and that's why his attorney kept bringing up Kelsey. So again, just to clarify what happened with Kelsey, clearly Kelsey has been compromised. Okay, so before they come to court, they have some sort of meeting with the police. I forget what it's called. It's not an interrogation, but it's like an interview. It's like an interview, but there's a name for it. It's like a pre-interview, so that the prosecution can establish like the people that they want to bring in, and for the police, it was a police statement that she made. She went into the police department and she gave a statement just weeks prior to the no, she went and met with police and attorneys, prosecution and attorneys. Okay, it was something like that. Anyway, it was recorded and she did a whole interview and she pretty much testified as to what happened that night. And then a couple weeks later, mind you, we're in court, Tory's trial. She don't remember anything. She doesn't recall anything. She doesn't know anything. So in this case, because she doesn't recall things, she's pretty much, obstructing justice. You know, this is how you call perjury. She was perjuring herself. Well, she had already got immunity prior to coming, because that's how you knew that they planned this. They were trying to create reasonable doubt. But she didn't remember anything. So the judge made the decision to play the audio, which was recorded just a few weeks before. The same question that she's being asked in court. But now on the stand, it's time to testify. She doesn't remember. Mind you, she did this interview under oath as well. Everything is done under oath, which is part of the reason that it was able to stand in court. My. Like this video, like this video, like this video. So again, we won't be hearing back today. We won't be hearing back today on the appeal, but soon. Kelsey couldn't choose from the D or the friend. Interrogatories. Okay, I think that's what it's called. I mean, maybe. You're right, Amber. He should have testified. He should have. I was watching King when he was there. He did a great job on the coverage. I'm trying to told you when. Community D belongs to the community. That's what I heard when girl la, 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 la. I think Tory was supposed to be producing Kelsey's next album. So for a while. I don't like that shit. Man. Jackie went to her court hearing. Jackie went to nobody court. Jackie went to nobody court. Like this video, like this video. Remember to support the show. We got Cash App, Super Chat, Venmos there. Okay, so the likelihood of Lanez appeal being granted and him getting out is slim to none. Okay. Very poor win. Okay, I could have did better. Okay, I wonder how much he's paying these people. Win. Okay, and do the time at this. What that word? Is it like to be able to? Yeah. That's how it happened. When that's how it happened. When friend, yeah, they was at the Kardashians' house. Kylie Jenner, yes, invited Megan over for a girls' day or whatever. And of course, she took her best friend Kelsey, and then they called Tory. You know, Tory was very excited to be there. They were in a hot tub. Tory didn't even have any swimming trunks on, so he decides that he's gonna hop in his boxers. Okay, fully exposed. Kylie was, intrigued, okay, and they were flirting with one another, and this made Megan a little jealous, and she was ready to go. At this point, by this time, Kelsey had already passed out. Okay, she's drunk. She's drunk as fuck. She's somewhere passed out. She has to wake her up so that they can leave. So they wake Kelsey up. She's like, grab my stuff, and they head out. Okay, and she's like, Tory, let's go. So Tory decides that he gonna stay. So she's like, all right, she's not trying to put it on scene or whatever, you saying. So her and Kelsey go get in the car, and they leave. They get down the street and Megan realized, oh, girl, I forgot my slipper. I only got on one slipper. She ain't forget no slipper. She got down the street. She started thinking about my man. She said, let me go back and get my man because he got me fucked up. Okay, period. Besides, this is his car. Okay, because they was with his driver. We need to go back and get him. Okay, period. And why would she leave him there anyway? He wasn't invited over there. She was. Like, that's her friend. Like, it's time for you to go. Oh. Anyways, so she go back up in there. She get her shoe, I guess. I don't even know if she got her shoe, but she got her man. She definitely got her man. Okay. She got Tory. Okay, on period. Because she went in there, they start arguing. Kylie was like, y'all gotta go. Y'all gotta get the fuck ASAP. She said, I don't care what y'all do, but y'all gotta get the fuck up out of here. So they run up out of there and they hop in the car and they get to arguing in the car, and the driver is driving. Well, at first when they get in the car, they said it was quiet, but then they get down the street and they start to argue in the car. And jealous this and jealous that, and my music this, my music that, something. Yeah, it was something. It was, Megan had clearly made the little man feel some type of way when she had they were arguing about, who was like a bigger entity. And Megan she had to let him know, like, bitch, I'm bigger than you. I'm the star here. Yes, it did. He felt some type of way. Girl. He shot her. Mm-hmm. It's a lot more to it, but I ain't got all day. Like this video. Like this video. Weird. Yes, it did. Let me know your thoughts in the chat. Do you guys feel like Tory Lanez appeal will be accepted or rejected? Let me know in the chat. Shout out to the replay gang. Let me know in the comments below. It's the Fish King Payne Show. Shout out to everybody here. Damn. Shout out to everybody here. Shout out to everybody watching. I'll talk to you guys all very soon. Until next time, I gotta go check on the critters. Y'all coming over to the Crown Family channel? Come on over to the Crown Family channel right here on the YouTube. Where the critters, the critter had court today as well. When a trial setting when. So I'm trying to figure out when the trial, if the trial date has been set. And if so, when? Yes, it is. If so, when? Until next time, you guys, I love you all with the love of Jesus, and I'll talk to you all soon. Thanks for watching. Adios.